Hello folks, Investigative blogger Crystal Cox here, and I want to talk to you today about the Obsidian Finance Group versus Crystal Cox case. Today is April 24th, 2014, and I got notification in the mail today. This is from the Office of the Clerk, Supreme Court of the United States, and they have sent me verification that my petition for appeal was docketed. Now what that means, folks, is that they docketed my appeal in the Obsidian Finance Group versus Cox case to the Supreme Court that I did. Now if you remember, if you've been following my case, you know that Eugene Volokh filed a motion to rehear in the 9th based on what the Supreme Court or the 9th Circuit judges had said, accusing me pretty much of extortion. Okay, they said that Cox had a history of basically extorting people. Okay, so Eugene Volokh is my attorney in the 9th, and he filed a motion to rehear. Now, the 9th Circuit judges denied this right. They just threw it out. It is not right for the 9th Circuit judges or any judge, especially an esteemed panel of judges, to accuse you of a crime in a civil case just as an incidental thing to just throw into the case, has nothing to do with the merits of the case whatsoever. Okay? This is not a matter of law. This violates your constitutional rights. This violates your rights of due process. And I made a stand against this. Okay? I asked Eugene to file this, and he did. Okay, now they denied the right, and so I'm filing to the Supreme Court. Now I'm doing the Supreme Court filing pro se, okay, and I represent myself in the lower court too. Eugene Volokh still represents me at the 9th. I know it can be very confusing. But at any rate, this is the statement that it was docketed, which basically means that it doesn't mean they accept it, it doesn't mean they'll hear it, it doesn't mean anything like that. It just means that it's on the docket. So whether they reject it or not, or it's just tossed out or whatever happens, at least I have made a stand for all citizen journalists, whistleblowers, and investigative bloggers. Because if this can happen to me, it can happen to you. The idea is to discredit it. So you have a case that's this amazing for all bloggers, all people trying to expose corruption, and you have equal rights to any of the biggest reporters in the court of law, but then they throw in this pot shot. So whether or not you think I'm guilty of extortion or not, that's irrelevant to me, really. Okay? If your opinion is that I'm guilty, fine. But you have to agree that it's not the proper courts, okay? Even though you got Tonkin Torp attorneys, David Amon, Stephen Wilker, you got Mark Randazza, you know, and all these attorneys coming in and hating on me and saying I extorted them and accusing me of extortion on all of these dockets. That doesn't mean I'm guilty of extortion, and it certainly means I have not had due process. Okay? You have all these judges, all these attorneys accusing me of extortion, but nobody's filed the criminal complaint. Okay? So this is dated April 16th, 2014, and it says, Dear Ms. Cox, the petition for a writ of certiorari in the above entitled case was filed on April 8th, 2014, and placed on the docket April 16th, 2014, as number 13-9731. Okay, 13-9731. And then they signed it, and then there was a form that was included to let the other side know, but the other side's already let me know, Tonkin Torp, that Stephen Wilker will be handling this. And this one says that in the Supreme Court case 13-9731, Crystal Cox petitioner, Obsidian Finance Group respondent, and then it's just entering Stephen Wilker as the lawyer on this case. It gives his phone number and email and all that. Okay, so I want to tell you a little bit first about, I want to revisit the recent case, Randazza versus Cox. So where you have, I know I'm mixing cases here, but I'm doing that for a reason. You have the 9th Circuit judges saying that Cox has a history of basically extortion, of posting things online and asking people for money to remove them. I have no history of that. There's no evidence of that on the courts. I've never been on trial for that. It's never been a material factor in my case. The evidence that the 9th Circuit used basically convicting me of extortion without due process, violating my constitutional rights and the Bill of Rights, was a New York Times article. So they're saying that I have equal rights as the New York Times, but they're also saying that let me make sure this is recording. They're saying I have equal rights as New York Times as a blogger, but they're giving the New York Times more rights over me by saying whatever they posted about me is true. So I have a history of extorting people and a felony crime, and based on something that a New York Times reporter said. Okay, so they basically took the equality away. Now, they have no right to just throw in an ad lib. I mean, they could say, if this is true, then judges can throw in anything they want and accuse you of anything. They can defame you and slander you. Well, basically, the judges would not hear the motion to rehear. Well, of course not, okay? Because they're the judges who made the error. They, of course, voted not to rehear the error and admit to their error. So I wanted to file to the Supreme Court. Now, people are slamming me, of course, and saying that I should just shut up and take the win. No. I was not in this to win and to get out of the judgment. I was offered 15 settlements to get out of the judgment. Okay, I was in this for very spiritual reasons, for a very higher purpose, to give voice to the victims of corrupt courts, okay, to change the world, to give all of you the right to be, have the same rights as news, to end the monopoly of free speech that big media has, okay? So these judges, for this, so basically I didn't do it just to get out of it. I wasn't looking to just get out. So they're like, you should just take this win and go, yay. Okay, yay, I'm glad that the win, but I still got a job to do, okay? So throwing in that pot shot at me throws it in at all citizen journalists, all whistleblowers, all of you out there exposing corruption, okay? It's not right for them to just throw that in there. Now, if these judges, who your tax dollars are paying their wages, if they think that I'm a harm to society, isn't it their job to uphold the Constitution and the rights? Isn't it their job to file a complaint? All they have to do is let the FBI know, right? Let the Department of Justice know, Attorney General know. In the Obsidian case in the lower court, the Judge Hernandez said that he was going to call the FBI about David Amen and Sean Boucher conspiring against me. Judges have the right to, and the obligation to warn the public of people, that they think that are committing felony crimes. Instead, they just threw it in as an opinion, basically, ruins my life, okay? So then everybody runs with that. Okay, if you go back in time to when Eugene Volokh filed a motion for me to have a new trial in the Obsidian case, the judge said there, well, no, we're not going to give it to her, and he accused me of extortion in that ruling. Okay? No reason to do that at all. It was based on hearsay. There was no reason at all. It wasn't part of the case, okay? At the actual trial, there was no evidence of extortion. There was nothing about extortion. You can see the day before the trial, I asked the judge, I said, well, he's accusing me of extortion. Do I have any rights in the criminal justice system? I think it's on page 15 of the trial transcript the day before the trial. And the judge said, he's not accusing you of extortion, okay? So they're all got me accused of extortion, okay? Then you got, in this motion to rehear, Mark Rondazza coming in, and then you got him paying basically the way for Martin Cain to come in, and all of these folks saying, I extorted them, I'm guilty of extortion, and they want this just thrown in with no due process of law whatsoever into a civil case ruling. Now, these are attorneys, and they want this. They hate me so much, they want this. But in getting this for me, they get this for all of you. Okay, so New York Times reporter says, you done something bad. And then judges put it on the docket and attorneys, and there it is, it's law, okay? So the reason I'm going to Rondazza versus Cox here a little bit is to show you that finally a judge actually called it out. So you have all these other judges, the Ninth Circuit judges, Judge Hernandez, you have Mark Rondazza, you have David Amen, Stephen Wilker, Martin Cain's attorney. You have all of these people saying that Crystal Cox is an extortionist based on all this, okay? So, but this judge actually said that it was circumstantial evidence, and, so I'm just going to read to you a few things that from that case. Now, this is docket entry 200, and it is Rondazza versus Cox, which is where Mark Rondazza sued me out of Nevada, basically just to shut me up and suppress my First Amendment rights. You can see, or you can listen to my video about this thing. I read the whole thing. he has superior knowledge of the law, but he has no leg to stand on in any of this stuff. He's just used it for 2 years to harass me and shut me up. And he claims to be a First Amendment lawyer, but he's attacked my First Amendment rights. Okay, so just a few highlights from that summary judgment. The cyber squatting case arises out of the alleged targeting of plaintiffs Mark Randazza, and by defendant Crystal Cox. The Randazzas allege that Cox and defendant Elliot Bernstein have engaged in an online harassment campaign to extort them by registering dozens of domain names that incorporate the Randazzas' names and then demanding that they agree to purchase Cox's reputation services to remove this alleged defamatory material from the internet and rehabilitate their cyber reputation. Cox maintains that this lawsuit was instituted to harass her and stifle her First Amendment freedom of speech and expression, which it totally was. I never ever put anything online and then asked Mark Randazza to give me some money and I'll remove it. That never even ever happened, okay? And if it did happen, then we need to see some proof and we need to get me in a criminal court, okay? Not just put it on all these dockets in order to take my intellectual property, take my search engine ranking, take my First Amendment rights, okay? In other words, chill my speech. Okay. So basically, okay, in November 2012, the Randazzas sued Cox and Bernstein, alleging violations of individuals' cyber privacy protection for various registered websites under 15 U.S.C. 8131. And cyber squatting. Okay, now basically the summary judgment says that all of this is, it's just mute, right? And basically trademark file lawsuits and stuff like this don't matter if you're not using a site for commercial, which I never was. Okay, it says, Cox also strongly objects to plaintiff's characterizing of her motivation and actions as extortion. Okay, now, page 4, she's talking about, the judge is talking about evidence that you can't have in, okay, that he hasn't authenticated it. And one of them is periodicals. It says plaintiffs offer in an article of Forbes magazine purporting to be a newspaper or periodical is self-authenticating. So it's saying, okay, Forbes is Forbes and it's self-authenticating that way. Thus, this article is self-authenticating. But its contents, however, are hearsay and not subject to any exception. Accordingly, the periodical is not admissible for summary judgment purposes. Okay, so a Forbes article is hearsay. So is the New York Times article. But you have a 3-panel esteemed judges in the Ninth Circuit that use this hearsay and quote the New York Times David Carr article as some sort of proof that I am guilty of extortion. Now what's interesting here too is that Judge Gloria Navarro used Jordan Rushy, which he's now a Randazza Legal Group attorney. He was, I think, with his own law firm in Pennsylvania, used his blog as hearsay and evidence as proof to get an injunction to take all of my intellectual property about 2 years ago when Mark Randazza first sued me. Okay, so then, let's see, right, that it's circumstantial evidence, you know, emails, the Forbes article, circumstantial. There's really no supporting evidence or any sworn documents. There's no proof of extortion. Mark Randazza doesn't even have like say, okay, if we have a blog post of a certain date that says bad things about Mark, and then you got me saying, hey, if you give me such and such amount of money, I'll remove bad things that I said. Okay, or if you don't give me this amount of money, I'll post bad things. Okay, there's no such evidence that exists. Okay, so there is that. Okay, so next here I want to read to you a little bit from the motion to rehear. Make sure this is still recording. Okay, now if you remember it, the motion to rehear, Eugene Volokh filed that, and that was I won the case at for some reason it's not coming up right here. January 17th I won my appeal, and we filed this on January 31st. Okay, and so basically it's called a motion to rehear. Petition for rehearing. Okay. And you guys can just, you can Google Eugene Volokh petition to rehear, and you find this. Because, I'm pretty good at getting things found in the search. Okay, petition for rehearing. Appellant Crystal Cox does not ask this court to modify the substance of its opinion. She does, however, respectfully request that the court amend its opinion to withhold the sentence that now says, Cox apparently has a history of making allegations and seeking payoffs in exchange for retraction. See David Carr, When Truth Survives Free Speech, New York Times, December 11th, 2011. A judicial assertion of misconduct by a named person, even a judicial assertion modified with the word apparently, could be based on the record in a case or an authoritative finding by another court, but it ought not be based on a newspaper column, which was written without the benefit of cross-examination, sworn testimony, or other safeguards of the judicial process. The claims in the columnist's assertion are neither facts found by a fact finder nor facts subject to judicial notice under Federal Rules of Evidence 201. Moreover, the New York Times column does discuss Cox's offering her consulting services to appellees in the case, but it does not make any such allegation about other cases. There thus seems to be no history of seeking payoffs claimed in the article. The history that the column is posting, it appears to be, is only a history of Cox's making similar allegations. So, basically saying that they used the New York Times as their proof, but they didn't even use that properly, okay? Because the part they referred to in the New York Times was actually saying that I had a history of, exposing corruption, basically posting things that I allege were corruption. And so judges do not have a right to take parts of things, twist it up, mangle it, and then have you accused of extortion, and then have media terrorize you. You get defamed and slandered by the judges. And not only that, but in my case, it's especially important that this does not happen, because I get a new trial, right? So if I have a new trial, if you're me, you'd be in the same boat. You have a new trial. You're going down back to the lower court for a $10 million lawsuit, because I was sued for $10 million by Obsidian, and you're already prejudiced, okay? So the jury already has a Ninth Circuit ruling that alleges that you're a criminal, so they're already prejudiced against you. So how am I supposed to get a fair and impartial trial when I have Ninth Circuit judges who have more power than the lower courts already saying that I'm guilty of crime? And if I've committed a crime against the plaintiff, well, then, of course, the jury's going to be like, hey, well, she screwed him over, and so they prejudiced me, right? That's not proper. It's not lawful. It's not constitutional. Okay. It goes on to say, unfortunately, but unsurprisingly, some media outlets have not only repeated this sentence, but even omitted the term apparently in doing so. The widely reprinted Reuters wire service, for instance, wrote, according to the court's opinion, Cox has a history of making allegations of fraud and other illegal activities and seeking a payoff in exchange for retraction. That was written by Dan Levine, blogger gets same protection as traditional press, when he was reporting on January 17th of my win. If anybody wants to represent me to sue Reuters or Dan Levine for defamation or slander, please email me, crystal@crystalcox.com or reverendcrystalcox@gmail.com. I have a good case against them and against Forbes and possibly even the New York Times, but I keep seeming to get those dismissed, but I have a really good case. So if you want to represent me, email me. That was just a side note. Okay, of course some such media omissions of qualifications such as apparently are inevitable. Still, they highlight the fact that when a statement is made in a court of appeals opinion, with the authority such opinion possesses, journalists might perceive the statement as a factual finding and not just a report of what a newspaper column has alleged. So, see folks, if it's put in a Ninth Circuit ruling, a 3-panel esteemed higher court ruling, that is deemed to be fact-finding. Okay? It is not proper or lawful for these judges to have just thrown that in there. I'm not saying that you should say I'm not an extortionist, okay? That's irrelevant. I'm saying that I want due process because I want that for all citizen journalists, all whistleblowers, and all anti-corruption bloggers, which is who I've been in this for from the beginning. Okay? I could have got out of the judgment long ago. It was never about me. Judicial opinions are perceived as extraordinarily reliable sources of information. This reliability stems from the assumption that statements in the opinion especially statements that allege misconduct, generally rest on adjudicated facts. Because of this, Cox respectfully requests this particular allegation, which relies solely on the claim made in a newspaper column, be redacted from the opinion. Okay, then I think it was around March 5th, the courts just said, no, we reject that and too bad and it's over. Okay, so I filed a Supreme Court appeal to this. I'm the petitioner, and I filed this, as you see, they docketed it. Well, let's see again what date they docketed it. They have the date on it as filed as April 8th, 2014, and docketed April 16th, okay? Now, I'm going to read to you some of this petition. Okay, just to kind of let you know what it is, I've posted it online as well. And you can email me, reverendcrystalcox@gmail.com, if you want a copy of any of these documents. Okay, introduction. It's easier without my glasses. Petitioner requests this court to issue a ruling that requires the Ninth Circuit to redact criminal allegations of petitioner in a Ninth Circuit civil court ruling dated January 17, 2014, Obsidian v. Cox, Ninth Circuit case number 12-35319. And then I give the lower court number. Okay, this issue is a matter that affects all members of the public. Ninth Circuit judges, Judge Arthur Alicorn, Judge Milan Smith, and Judge Andrew Hurwitz stated, Cox apparently has a history of making similar allegations and seeking payoff in exchange for retraction. And then it says, see David Carr, When Truth Survives Speech. Okay. Defendant Crystal Cox has no history of posting anything online and seeking a retraction for a payment. This is not based in fact and has never happened, as the court record clearly shows. Cox has never determined by any court to have posted allegations, then sought a retraction, then continued posting and was sued. This is factually incorrect. Cox alleges the Ninth Circuit violated her constitutional rights in alleging criminal activity and has stated in error the events leading up to her defamation suit. Cox asked this court to rule that criminal allegations be redacted from the Obsidian v. Cox Ninth Circuit ruling dated January 17, 2014. Petitioner Cox understands that it is the sole judicial discretion of this court to hear this matter. Cox prays that this court will hear this matter, as these judicial actions will potentially chill speech and violate the rights of other citizen journalists, whistleblowers, and anti-corruption bloggers such as Cox. Okay, then you got to present your questions. So questions presented. Petitioner requests this court to decide the following questions. Does petitioner, defendant, litigants in a civil case have a human constitutional right and right under U.S. Code to be considered innocent until proven guilty? Do Ninth Circuit judges have the legal authority to issue an opinion on criminal allegations in a civil case in which the criminal allegation is not a matter of record in the lower court, has not been adjudicated, and is not a material factor in the case? Does petitioner, litigants in a civil case, have a legal right to due process of law in cases where judges rule that litigants, such as petitioner, have committed crimes of which petitioner was not on trial for, nor was a matter of record in the lower court? Do Ninth Circuit judges have to find a defendant guilty of a crime beyond a reasonable doubt, or to have been adjudicated of that crime in a U.S. court before they rule that a litigant such as petitioner is guilty of this criminal behavior or criminal activities? Do litigants such as petitioner have a 14th Amendment right, Bill of Rights, and due process of law rights that have to be adjudicated for a crime before a Ninth Circuit judicial panel can issue an opinion in a highly publicized, higher court, esteemed ruling regarding that alleged crime. Do Ninth Circuit judges have a lawful right to use a New York Times article as adjudicated fact and material evidence to issue a ruling that a litigant in a civil case is guilty of criminal activity? Okay. Kind of lost my place. Is it lawful for Ninth Circuit judges to use gossip, hearsay, and the rantings of a New York Times journalist as adjudicated fact and use this as factual evidence in a Ninth Circuit ruling? Can the Court of Appeals prejudice a litigant with false and defamatory language in a ruling? Does a litigant have a right to have the language in the ruling challenged or reviewed by an independent court, for example, the Supreme or another appellate court not involved in the decision, with the defamatory and legally abusive language that prejudices the rights of the litigant in rehearing? Does the court have the right to defame and slander litigants and deny due process? Do judges have the right to convict litigants of crimes in judicial rulings based on New York Times articles? Do judges have a right to deny due process in lower courts by issuing a ruling that convicts litigants of crimes, thereby prejudicing them with a jury of their peers as they return to have a new trial? Do judges involved in a slanderous, possibly criminal, defamatory statements have a legal and constitutional right to rule on whether they rehear the issue of them acting inappropriately and unlawful in that very ruling? Is it lawful and within the constitutional rights of a defendant, such as petitioner, for a panel of judges to use a New York Times article